Imagine this. You live in a state, maybe Texas, maybe elsewhere, where cannabis is legal. For medicine, maybe even just regular use.
Right. You follow the rules, you think you're doing everything right.
But then, the federal government steps in and says, because you use cannabis, nope, you can't own a gun.
And this isn't some what if. It's happening right now. People are facing this dilemma.
And it might get even tougher. The U.S. Department of Justice, the DOJ, just proposed a new rule.
A rule that could make it almost impossible for cannabis users to ever get their gun rights back if they've lost them.
So today, we're going to break this down. We'll walk through this proposed rule, why it's stirring up so much trouble.
Yeah, and how the courts are actually fighting back against the federal ban. We'll look at what this means for your Second Amendment rights if you use cannabis.
Our mission here is to make this complex legal mess clear, so you understand what's really on the line. All right, let's get into it.
Okay, so the main thing is this proposed rule from the DOJ. Right now, they're taking comments from the public about it.
And it's all about how the government decides who gets their gun rights back after losing them under federal law.
Exactly. And here's the kicker for cannabis users. The proposal flat out says that people who use marijuana, along with other folks the feds call unlawful users of controlled substances, they're presumed ineligible.
Presumed ineligible. Okay, break that down. What does that mean, practically speaking?
It means if you apply to get your rights back, the default answer is basically no. You start behind the 8 ball.
So you'd have to prove some kind of really special situation.
That's right. Extraordinary circumstances is the term they use, and the burden's all on you to prove it.
Wow. And what's the DOJ's reasoning for taking such a hard line?
Well, Attorney General Pam Bondi put it out there. They're saying cannabis users show, and I quote, a lack of respect for the law and potential dangerousness.
Potential dangerousness.
Yeah, they even claim marijuana use inherently makes people dangerous. That's a pretty bold statement.
Especially with so many states saying it's okay, even for medicine. Where does this federal power come from?
It comes from an existing federal law. Section 922G3. This law makes it illegal for unlawful drug users to buy or even just have guns or ammo.
An unlawful user include people using marijuana legally under their state's law, even medical patients.
I've got it. Federally, marijuana is still a Schedule I controlled substance. So under federal law, any use is unlawful. State law doesn't matter. It's a strict blanket ban.
Okay, but does this proposed rule make any difference between someone using now versus someone who used in the past?
That's a key point. Yes, it does draw a distinction. The rule seems pretty clear that current unlawful drug users, they're likely getting denied. That presumption of ineligibility hits them hard.
But what about someone, say, with an old drug conviction, maybe a felony under a different part of the law, like 922G1? If they stop using, can they get their rights back?
Potentially, yes. That's where there might be a path. The rule suggests that if you had a past felony conviction but you've stopped the drug use, you might be able to take yourself out of the prohibited category. So someone who quit could possibly apply and be considered. But if you're using now, not likely.
So it really hinges on whether the use is current or not in the eyes of the DOJ.
Seems that way. It's about present conduct versus past conduct.
And I saw something about local cops getting involved too.
That's right. If you apply to get your rights restored, your local chief law enforcement officer gets notified.
So the local sheriff or police chief?
Exactly. And they can even help gather info about your application, maybe talk to people who know you. Adds another layer of local review.
Okay, so this rule is out there. It's got these definitions, this past versus present thing. People listening might be directly affected. Can they tell the DOJ what they think?
Absolutely. And they need to know this. There's a 90-day public comment period. It actually closes on October 20th.
October 20th, so there's still time.
Yes. You can submit comments online through the Federal Register where the rule is posted. It's a crucial chance for people's voices to be heard before this thing becomes final.
Let's take a quick pause before we continue.
If you're listening right now and you believe in what we're doing, educating, empowering, and helping real people navigate the justice system, then consider becoming a sponsor of the Legal Gangsta podcast.
This isn't just a show. This is a movement.
We don't take money from lawyers or legal aid. We stand on truth, faith, and real solutions for real people.
If you'd like to be a sponsor, contact the Legal Gangsta management team today at
legal-gangsta.com.
That's legal-gangsta.com.
Now let's get back into it.
All right, so the DOJ is pushing this rule, trying to lock down this ban. But you mentioned the courts are pushing back. What's happening there?
Yeah, this is where it gets really interesting. Over the last few months, several federal appeals courts have started asking serious questions. Like, is this blanket ban on gun ownership just for being a drug user even constitutional?
On what grounds?
They're looking at history. They're saying, historically, when were people disarmed? Usually for specific dangerous actions, not just for belonging to a broad category like drug users. There's not much historical precedent for a ban this wide.
Can you give an example? Which courts are saying this?
Sure. Take the Eighth Circuit Court of Appeals. They threw out a conviction, basically said the ban is only okay in certain circumstances, not automatically.
Not automatic, okay.
And they specifically said history doesn't support disarming someone just because Congress labels the whole group drug users as dangerous.
Wow. That directly challenges the DOJ's inherently dangerous argument.
It really does. And then you have the Third Circuit. They went even further.
So?
They said courts have to look at each person individually, make an individualized judgment to see if disarming that specific person is actually necessary to stop them from being a physical danger.
So no more just lumping everyone together?
Exactly. They pointed out that old laws about disarming people for, like, drunkenness or lunacy always involved looking at the individual's behavior, not just saying all drinkers or all mentally ill people lose their rights.
That makes sense. Are other courts following suit?
Yeah, we're seeing similar rumblings and rulings from courts in Rhode Island, the Fifth Circuit down here, and the 10th Circuit, too. It's definitely a trend.
Okay, so multiple federal courts are questioning this. This sounds like it's headed straight for the Supreme Court.
It absolutely could be. It's definitely on their radar. There are 3 specific cases waiting for the Supreme Court to decide if they'll even hear them. U.S. v. Hemeny, U.S. v. Cooper, and U.S. v. Baxter.
And what's the government arguing to the Supreme Court?
The U.S. Solicitor General, that's the government's top lawyer for the Supreme Court, D. John Sauer, is arguing that, yes, Section 922G3 is constitutional.
Their argument.
They claim it targets habitual users of unlawful drugs who pose a clear danger. And they also stress that the ban is temporary. Stop using the drugs, they say, and you can potentially get your rights back.
Habitual users. That word keeps popping up. But didn't you say the actual law doesn't use that word?
That's a really sharp catch. You're right. The government's lawyers use habitual like 40 times in their Supreme Court brief. But the law itself, Section 922G3, it just says unlawful user of or addicted to.
Huh. That seems like a big difference. Unlawful user sounds way broader than habitual use.
It absolutely is. Habitual implies a pattern, maybe addiction. Unlawful user could mean someone who used just once, depending on how you interpret it. That difference in wording could be huge.
And it looks like the DOJ might prefer the Supreme Court to take up one specific case, Hemeny. Why that one?
Well, it seems strategic. The person in the Hemeny case reportedly used both cannabis and cocaine and also had a history of selling drugs.
Ah, so maybe not the most sympathetic person to represent cannabis users fighting for gun rights.
Potentially. Compared to someone in another case, like Cooper, who was apparently just found with weed and a gun, the government might think Hemeny gives them a better chance to win and set a precedent that keeps the ban strong.
But there's a risk for the government too, right? If the Supreme Court takes a case and rules against them.
Oh, absolutely. If the Supreme Court sides with the lower courts challenging the ban, that could basically say this federal law is unconstitutional, at least in some situations. That would be a massive shift.
Okay, so this is playing out in the courts, but what about the real world? What other things is the DOJ saying about cannabis users and guns?
Well, in other cases, the Biden administration's DOJ has made some pretty strong claims. Things like medical marijuana patients with guns endanger public safety, have a greater risk of suicide, or are more likely to commit crimes to fund their drug habit.
Wow. Those are serious claims against people who are often just following their state's medical advice.
They are. And it's not just one side of the political aisle either. Former President Trump previously talked about a possible link between genetically engineered marijuana and mass shootings. He wanted agencies to investigate it.
So it's a politically charged issue across the board.
Definitely. And you even see confusion within Congress. Remember Hunter Biden's conviction?
Yeah, for having a gun while using drugs.
Right. That led some Republican congressmen to ask, well, wait a minute, what about the millions of marijuana users who own guns? Should they all be prosecuted too? It highlights the inconsistency and the difficulty lawmakers are having with this.
It just sounds incredibly confusing for everybody involved. Patients, lawmakers, advocacy groups.
Totally.
Huh.
Even the NRA, the National Rifle Association, has acknowledged this. They said these court rulings are creating a confusing regulatory landscape.
What's the NRA's position on cannabis users having guns?
They don't have an official stance on cannabis policy itself, but they did say many marijuana users are otherwise law-abiding and productive members of their communities who want their Second Amendment rights. It shows how complex this is, cutting across typical lines.
Are states trying to do anything about this clash between federal and state law?
Yeah, some are trying. In Pennsylvania, a lawmaker put forward a bill to get rid of state-level barriers for medical marijuana patients having guns, trying to fix it within their own state borders.
Okay. What about other states?
In Colorado, activists tried for a ballot measure to protect gun rights for cannabis users, but they didn't get enough signatures, so the effort stalled there.
In Kentucky, they just started a medical marijuana program, right?
Yes, and the federal ATF immediately warned Kentuckians, join the medical marijuana program and you're federally banned from buying or having guns.
Putting people in an impossible spot.
Yeah.
Medicine or rights.
Exactly. So now Kentucky lawmakers are pushing for federal changes to make it clear medical users can have guns, and their governor supports rescheduling marijuana federally, which could resolve a lot of this conflict.
Okay, so wrapping this up, what does this all mean for you listening? It's a major clash, right? Federal law says no guns for cannabis users, period. Mm-hmm. States increasingly say cannabis is okay.
And now federal courts are stepping in, questioning that federal ban based on history and the Second Amendment. The DOJ's new rule tries to cement the ban, but the Supreme Court might just blow it all up.
This really goes beyond just guns and cannabis, doesn't it? It's about states versus the federal government, old laws versus changing society.
It really is, and it makes you think, what responsibility do lawmakers have here? Should laws automatically reflect how society understands things now? Or is it right to punish people based on these broad categories, especially when the category itself, cannabis use, is becoming so mainstream and legal in many places?
That's the big question hanging over all of this. A lot to think about.
Definitely a situation to watch closely.
Okay, that's our breakdown for today. If you need help navigating the justice system, especially right here in Texas, don't try to figure it out alone.
Visit legal-gangsta.com. That's legal-gangsta.
If you're in Harris County, go to legal-gangsta.com right now and get your 10-step Erase Your Criminal Record Guide. It's the roadmap you need to start your journey to freedom and a clean slate today.
Remember, that's legal-gangsta.com.
And hey, if you found this information valuable, please like this episode, subscribe so you don't miss out, and share it with someone who needs to hear it.
Leave a comment too. Let us know your thoughts. We want to hear from you. Until next time, stay informed and empowered.